Hello, Alexandra. It's nice to see you.
Hello, nice to see you. Sorry for being late, but I was on another panel.
No, it's great. We're going to start. We're going to start right now. I'm going to turn it over to my colleagues.
Perfect.
So, welcome everyone. It's a real pleasure to be here with you and our excellent panel today to talk about content regulation and human rights. For those live tweeting with us, please use hashtag GNI Forum. My name is Jason Pielmeyer. I'm the policy director at the Global Network Initiative, which for those of you who don't know us is a multi-stakeholder platform bringing together leading academics, civil society organizations, investors, and technology companies in support of freedom of expression and privacy in the digital realm. Over the last few years, GNI has been tracking an uptick in governmental initiatives that attempt to address harms in the digital ecosystem. These efforts range from court decisions and updated regulations to new legislative frameworks, and they focus on subjects like disinformation, hate speech, and ad tech. And they're popping up everywhere, from Uganda to the United Kingdom. And while there are many differences among these efforts, they clearly influence one another, and when analyzed together, certain trends emerge. In fact, that's just what GNI did over the course of the last year. We did a wide-ranging analysis reviewing over 24 content regulation initiatives, organizing 6 separate consultations with stakeholders across Africa, Europe, and Asia. That analysis and the resulting recommendations for how to make these efforts more consistent with and protective of user rights are summarized in our policy brief on content regulation and human rights, which we'll put a link in the chat to if you haven't seen it already. And that brief provides the background for today's event. So with that foundation, I just want to provide some quick ground rules and introduce our moderator, who will then introduce our panelists. Today's event is being live streamed and will be on the record. You're welcome to submit questions using the Q&A feature on your screen, and we will review those as they come in and try to get panelist responses to as many of them as possible toward the end of the hour. Our moderator today is David Kaye, who's a clinical professor of law at the University of California, Irvine, and as of last fall, GNI's independent board chair. From 2014 until 2020, David served as the UN Special Rapporteur on freedom of opinion and expression. He's the author of numerous UN reports exploring the nexus between technology, human rights, and corporate responsibility, as well as the fantastic book, Speech Police, The Global Struggle to Govern the Internet. So with that, David, I'll hand things over to you.
Great, Jason, thank you so much. I especially just want to start by thanking you and David Sullivan for organizing this session today. As Jason mentioned, we are at a kind of inflection point globally. We see legislation being proposed in all regions of the world. We see legislation discussed in democratic societies, and we see legislation being pushed forward in non-democratic and authoritarian societies as well. There's pressure on companies, but there's also pressure through that on speakers, on users, on audiences, and many others around the world. So we brought together and are bringing together today really a remarkable group of legislators and experts to talk about the way in which legislation is affecting freedom of expression worldwide and in very specific jurisdictions. So with that, what I want to do is I'm going to introduce our speakers. I'm going to give them a chance with a kind of leading question to start off with. To get the conversation going. We only have an hour. We have less than an hour at this point. So so I'm going to give them that chance, and then we'll have a back and forth and exchange and open it up to everybody toward the end. So with that, let me introduce our speakers. Our first panelist is Tom Malinowski. He's a Democrat representing New Jersey's 7th District in the US House of Representatives. He served as Assistant Secretary of State for Democracy, Labor, and Human Rights in the Obama administration. And I believe he was Executive Vice President of the Berkeley student body at some point in our shared past. Shazia Mari is Information Secretary of the Pakistan People's Party and a member of the National Assembly representing Sindh province. In Parliament, she played a key role opposing Pakistan's 2016 Prevention of Electronic Crimes Act, an act that has served also as a model for very significant and repressive approaches to freedom of expression around the world. Alexandra Geese is a member of the European Parliament from Germany, representing the Greens and the European Free Alliance. She is responsible for the Digital Services Act in the Internal Market Committee within the Green Group and coordinator for the group in the Special Committee on Artificial Intelligence. It's hard to think of two other issues in European space right now that are getting deservedly more attention than the DSA and the AI work that Alexandra is responsible for. And finally, Agustina Del Campo directs the Center for Studies on Freedom of Expression and Access to Information, CELE, at the University of Palermo in Argentina, where she leads a legislative observatory that tracks laws and bills on freedom of expression in Latin America. So thank you all to our panelists for joining us. I'm gonna start with a lead-in question, and Tom, if I could start with you. Obviously in the Capitol on January 6th, you experienced firsthand the offline violence that can result in part from online organizing and online incitement. Last fall, you introduced the Protecting Americans from Dangerous Algorithms Act, but you also supported and have supported for many, many years, internet freedom and human rights online, particularly at the State Department and before that with Human Rights Watch. So with all the highly politicized discussion of the role of Section 230 in the United States today, could you give us a little flavor for what your bill aims to achieve and perhaps how it differs from, because there's obviously a slew of new legislative proposals out there. How would you distinguish it from the other proposals that are out there right now?
Thank you, David, and thanks for having me on. And as your question suggests, it's complicated, right? And you're absolutely right. Most of my career, all the way through today, I've thought of myself as a human rights advocate and a champion of freedom of speech online and offline. Jason Pielmeyer and I partnered on those issues when we were at the State Department together under President Obama. We believed, and I still believe very, very strongly, that government should not censor speech. I do not believe that government should be telling online platforms to censor, block, label, alter any content. That's not the job of the US government, and I certainly oppose it when I see the Chinese government or the Ugandan government or the Pakistani government or any other more authoritarian government trying to censor speech online. By the same token, and this is an important piece of the debate in the United States, I don't think the government can tell private companies that they can't block content or enforce terms of service by the same principle. You and I have the right to put up a website of dog lovers in which we say you can't post pictures of cats. That's our right under freedom of speech, and governments can't tell us not to do that. So I still feel very strongly about that. What my bill addresses is something quite different, though, because there is a problem. What happened to the United States Capitol on January 6th was just one manifestation of that problem, and it happened to be a manifestation directly experienced by members of Congress in the United States, and so it's getting a lot of attention right now. But there you had a mob of people, thousands of people, who absolutely were radicalized in a digital echo chamber created by Facebook and Twitter and Google and other online companies. They sincerely believed in the fantasy that had been propagated by, of course, President Trump and others supporting him, but propagated and cultivated in these online platforms to the extent that when they stormed the Capitol, they believed that what they were doing was not deviant or criminal, but absolutely normal. And they believed that the overwhelming majority of Americans believed exactly the same thing that they did. They are shocked today to see that that is not the case. But in that moment, they believed it because everything they see, literally everything they see online reinforces it. And this is a development over the last 10 years or so. It's not happening because there are bad people posting bad stuff on the internet. There have always been bad people publishing bad stuff. It's happening because the social networks are consciously designed to put us in these digital echo chambers. They are consciously designed to give each and every human being on the planet increasingly hateful versions of what we already hate, increasingly fearful versions of what we already fear. Content that is individually tailored to trigger those emotions, because they figured out that that is what, given human nature being what it is, that is what keeps us glued to our screens the longest, so that we see more ads and buy more stuff. And that is breaking apart democracy in the United States. It is a threat to democracy and human rights everywhere. In fact, it's affected countries like Burma, for example, and plenty of others far more virulently than it has affected the United States, right? We're waking up to it, I think, in developed democracies. And so what my bill doesn't tell the companies to censor anything. It doesn't tell them to do anything on content moderation. What it simply does is to say that if you are actively promoting, not allowing others to post, but actively promoting through your algorithms, content that can be shown to lead to extremely severe offline real-world harm, an act of terrorism, violent hate crimes, and we define these things by reference to several existing civil statutes in the United States, then you are not protected from liability under Section 230 of the Communications Decency and Decency Act, which means you just have to answer in court, right? You may win those court cases, you may lose them, but you are exposed to the same liability that you or I would be exposed to if we could be credibly accused of inciting that kind of violence. And the goal is to incentivize these companies to take steps that we know that they can take, because many of them have already temporarily, experimentally adjusted their algorithmic promotion to deal with these offline harms. But again, only temporarily, because at the end of the day, they make the most money when we are glued to the screen the longest. And we can talk about some of the specific reforms that I could see them making if they were incentivized to do so. We know what they are because, again, they've experimented with some of these things. That's what we're trying to encourage. Thanks.
Great, Tom. Thank you so much for that introduction. I'm sure that many of our participants are going to have questions for you. But before we go to those questions, I want to turn to Shazia Mari in Pakistan, because in part, I think much of what Tom Malinowski just highlighted is a global phenomenon. It's clearly not a phenomenon that we see only in the United States, but it's particularly because the platforms are global and they operate at scale. The same kinds of offline harms that we've seen in the United States are happening elsewhere. And in Pakistan, the government has taken a different approach than what Tom has outlined. The government has introduced a broad set of rules that put internet companies at risk of pretty serious fines if they fail to stop the sharing of a vast number of, frankly, vaguely defined categories of content. And I wonder, Shazia Mari, if you could talk about what the fallout has been and what lessons the rest of the world might draw from what you've seen and what you've worked on in Pakistan.
Thank you, David. Thank you for making me a part of this discussion. I, as a legislator, was working on the Prevention of Electronic Crimes bill that came in 2015. I was a member in the opposition then. And I looked at the draft, which was disturbing in many ways, which is why we had deliberations and we had marathon meetings. We proposed amendments. There was a lot of debate that went into a lot of time given to that legislation. And we were able to get some people on board after a lot of hard work, because the then government was not allowing discussions or meaningful consultations that we thought was an integral part of the legislative process. However, we did get some people to come on board. We did get some views from stakeholders, but unfortunately, those views, those suggestions were not incorporated the way I'd like, or I'd at that point in time proposed, or other stakeholders had proposed. And unfortunately, the fears that we had at that point in time have now come true, basically. And we see that the main concern that I had then and I have today is the violation of fundamental rights, the basic constitutional rights that are available to us in the Constitution of Pakistan. So if you read the Constitution of Pakistan, the chapter 2, which is part 2, talks about fundamental rights. And this very legislation, when it came in 2016, it was enacted upon. The fears that I had then as a legislator have now come true. The rules that you were talking about are very recent, which are framed in light of the same legislation. And there seems no consultation while making these rules. I don't see any consultation, any meaningful dialogue has not gone into this. Stakeholders are kept in dark. And as a result, you see that as soon as these rules were brought about, were introduced, there was resistance, there was objection, and also to a great extent rejection of these rules. So much so that just yesterday, an honorable court in Pakistan has taken cognizance of these rules, and the government of Pakistan has assured on the forum that they are going to revisit these rules. So I feel, David, that it is very important to understand that if we want to regulate content, there has to be a process. And the process has to be transparent. What I see today, that Pakistan Telecommunication Authority, which is a regulator, has been given a lot of power. I mean, they have the power to act as a judge. They have the power to decide about the user or a website, but they do not apply the kind of restraint or the wisdom that is required. So they are using the sections of the law, and sadly, I have to share with you that they had blocked around about 800,000 websites. And this is what the court took cognizance of, which is why they objected to how the PTA was working as a regulator. And my concerns back in 2015, like I said, that they are very much true today. And I feel that the government in 2015 did not realize. The same is happening today, that the government in Pakistan is not realizing that when this government as a party was in opposition in 2015 and opposed this very bill, is now supporting this piece of legislation and the rules that it has brought in light of the same legislation. So I would reiterate the same thoughts, the same stance that I had back then, that we need to be very careful when we bring about legislation that is to regulate content, because in doing so, if there is a dictatorial approach taken by an authority, then we only see the bad results, which we see today, because we see a lot of censorship. We see a lot of action taken against websites and the civil society, the journalists, but we don't see the protection of content. We don't see the very sort of protection for human rights or the fundamental rights that are guaranteed to us in the Constitution of Pakistan. So it's a concern that I share with you today. I hope, because I'm a pessimist, I do hope for better sort of situation in future. We are working on it. We have challenged the previous bill, and we've also challenged the rules that are framed in light of the same bill. I hope that I hear other participants on this forum, and I'm able to sort of take this lesson and use it back home, because we are in the process of fixing this problem that started back in 2016 in form of a law, which was not what I as a legislator or we as civil society in Pakistan approved of.
Shazia, thank you so much. And I really want to emphasize, before I turn to Alexandra, the points that you make about consultation, about social ownership of a process that, from what I understand, has largely been avoided by the government. And I really appreciate that, and the aspect of transparency that you mentioned, in part because what you're describing is the creation of law that can be subject to really extensive abuse by government, something that Tom mentioned at the outset as well. Alexandra, if I could turn to you. Now, obviously in the European context, both because of the size of the European Union and its very significant influence on policymaking elsewhere around the world, I know that you're very attentive to not just the scope of the law that you're looking at, but also the way it can be modeled around the world. The proposed Digital Services Act could be quite consequential, not just for Europe, but for global regulation of the internet. And so with this in mind, I wonder if you could talk a little bit about the key safeguards that you think either are or should be in the DSA to ensure that regulation doesn't go, or at least provide a pathway for infringing on fundamental rights.
Yeah, thank you very much. And thank you very much for having me. Maybe just to start, I would like to say that I personally share the analysis made by Congressman Malinowski, which is exactly what we feel in Europe as well. I mean, it's really the business model of the companies that is the problem. Extracting value from human experience brings you to enhancing strong human feelings, strong human experiences, anger, fear, and that is really part of the problem. So, and I think this is quite present in the thinking of the Commission even before the events of Capitol Hill. I think the intellectual analysis made by the European Commission was amazing, acknowledging that, and that we should not only stay on that level of regulating single pieces of content, but trying to understand what is really the model behind it. Why do we have so much problematic content? But then to come to the details and to your questions, the Digital Services Act is the follow-up of the e-commerce directive from 2000 that has accompanied the birth practically of the internet, of modern social networks, and now we feel it's not enough anymore. But the respect for human rights and for fundamental rights, I think, and the global responsibility we are having here in Europe is something we feel deeply. And therefore, I think there are some good safeguards in the Digital Services Act. First of all, we're going to maintain the safe harbor regime, which is more or less what the equivalent of Section 230 is, with some differences. So as long as a company doesn't have actual knowledge of an illegal content, it's not liable. Once it does have knowledge, it is liable. So maybe that's a little bit the difference. But and this is being upheld. Then there is still a general ban on general monitoring. So platforms are not supposed to generally monitor the content. They can do that voluntarily if they have the feeling there's a lot of illegal content, but the government can't force them to do that. Then we have what is new. It's a notice and action system. So it's basically clear rules on how the companies have to deal with illegal content, and only illegal content, not harmful content, just illegal content. That was until now sort of arbitrarily. Every platform did what it wanted. There was a lot of illegal content of different kinds on the platforms, and in the future with the DSA, we're going to have a set of rules. For my part, I think the set of rules that is being proposed is not enough. It needs to be more differentiated, clearer, and so on. But I think it's a good start we can work with. Something else that is really new, I think, is the obligation for an annual transparency report on content moderation, on takedowns, and so on. Every single event really has to be in a comprehensive report, and these reports need to have a standard, so you compare a Facebook report with a Google report, with a Twitter report, and so on. We've already had that in Germany, but since there was no common standard, you couldn't really compare them. They were not helpful because you couldn't really read the information, and there were no clear rules. So everybody, and in the end, the companies that took more content down looked as if they were tackling hate speech more effectively, but there was no necessary correlation between the effectiveness of the platform, the Twitter report, and so on. So no, we're going to have that. Another very important point that we have been advocating very strongly is more transparency, in the sense that under certain conditions, independent researchers, academia can access the data, can access really the raw data, the algorithms, and so on, in order to find out whether they're complying with the DSA, to do research on certain aspects, and so on. And there are mandatory risk assessments to be done annually by the companies themselves, which I think on the one hand is a good thing, because they really have to assess the risk of hurting fundamental rights, for example. So the companies need to take responsibility. On the other hand, I'm a little bit critical, because seeing what some companies do with their own staff, thinking, we mentioned artificial intelligence before, Timnit Gebru being fired from Google for writing a critical paper and so on. So I don't have that much trust actually in these companies to do their own risk assessments. And then there is a provision on independent auditing, which sounds great, but this would be the big for basically the big auditing companies, and I have some doubts that they have the skills and the independence to really do that. So we have these companies that are so big that they're difficult even to audit. I think it's going in the right direction. I personally feel it's not enough yet. What is still problematic is the issue of terms and conditions. And on principle, I agree with Tom Malinowski saying, well, we don't want to regulate private companies and what they should and should not take down and so on. But then the question, is a network with 2 billion users collecting data on all these people, is that really still a private space? And in many countries, we don't really have alternatives. So we have an intellectual, not a legislative, but an intellectual debate going on, at least in Europe, and I suppose you have too. Is that really a public space? Is that a private space? Which rules can be applied, and how much can we regulate those spaces? I think this is a challenge we're not solving yet. And if I may, just a personal point, when we speak of freedom of speech, we have surveys in Europe seeing that 50% of people are saying, I don't express my opinion freely in the internet because I'm afraid of hate speech. And a lot of the hate speech is not illegal. I mean, the hurdle for it being illegal is high. Like death threats in Germany are not illegal if there's not a time and a place, for example. And many people, even in Europe, where you have really good guarantees in terms of fundamental rights in most countries, don't express their opinion. And those are especially women, those are especially young people, those are people of color. And that's a limitation to freedom of expression too. So we always have trade-offs, and I think we need to think even further. We can't stay only at the surface. I think at the surface, the DSA is pretty good, but we really have to face also these intellectual challenges. What kind of content do we really want to have? Are the limits between illegal and legal speech enough to solve the whole problem? I don't think so. I think we need to go further. I stop here for the moment.
Great, thank you, Alexandra. That was very provocative, and in fact, there's so many issues in there around transparency, around how you, as legislators, think about the rules that the companies should be applying. I mean, your last point, I think, is really quite an important one that people are talking quite a bit about now, which is, should the public law understanding of something like incitement be the same kind of rule that the companies impose when they are moderating their own content? And it seems to me that a lot of the debate has suggested that the rules can be and should be different, but maybe we can drill down into that in a moment. I want to turn really last, but definitely not least, to Agustina Del Campo. Agustina, from your academic perspective and from your perspective of observing these issues over many years and working with multi-stakeholder groups, with academics, civil society, companies, parliamentarians, how do proposed regulations, whether in the United States, in Pakistan, in the EU, how do those ripple outwards to other regions? I mean, are you seeing the debate in Latin America on the legislative side similar to, varying from, echoing the debate that we're hearing from Tom, Shazia, and Alexandra just now?
Thank you, David. First, very honored to share the panel with you guys, and thanks to the GNI team for organizing this. So I'll start by saying that it's pretty hard to speak of Latin America as a whole, because it is a very heterogeneous and diverse region. And unlike Europe, we don't have a unified legislative body that we can turn to see if there are common ideas that we can put forward as a region or together. So what we are seeing through the Legislative Observatory are somewhat common trends that are happening across the region. And I think, as you, David, said a minute ago, these are concerns that are common to everyone, I think. It's not distinguishable by region. I think we're all concerned about the same issues, and that is showing in the different congresses around the world. But some specific common trends to Latin America that I'm particularly concerned about somewhat are most of Latin American countries don't have an intermediary liability framework. So this is different from Europe and different from the United States. The few regulations that we have on intermediary liability usually come through FTAs with the United States and are usually specifically on copyright issues. So what we have mostly imported into our legislation are DMCA provisions through free trade agreements. The exception so far was Brazil. And Brazil's marco legal is currently being constitutionally questioned precisely for the broader intermediary liability that it provided. So we're looking at a region where content moderation concerns, like the ones that you guys expressed, are being debated without having a basis to start discussing nuances within intermediary liability. So we don't have the general principle of what should companies be liable for. And therefore, there's somewhat of a big incentive for or big uncertainty as to what companies could be liable for in the region. And on top of that, we're starting to discuss some of the more nuanced issues like the ones my predecessors mentioned. The other thing that we're seeing is that there is a significant impact of particularly European legislation, and that's coming through imports, basically. There's a very close relationship between Europe and Latin America that has been there forever. And we're seeing a very big impact of legislations adopted in Europe that are coming to Latin American congresses. Two examples that I can mention, NETS-DG has had an impact in Venezuela and Honduras that approved laws that were sort of following that model. But very recently, last year, Brazil discussed quite a problematic law on fake news that was also following some of the precedents that were coming from Europe. I guess the good news is two good news to end my presentation on a positive note. One thing that we are seeing is that despite not having a general intermediate liability principle, we're seeing very good permeability of the inter-American human rights standards that have been developed, that the Special Rapporteur's Office has developed, and that have been developed through joint declarations of different special rapporteurs across the globe. So those are permeating the discussions in different congresses, and they are serving as a basis to debate initiatives that could otherwise be very problematic. The second positive note, and I'll leave it here, is I think there's a lot of hope in looking at the DSA in the sense that it, unlike legislation efforts or most legislation efforts in Latin America, the European legislation comes from a longer participatory process that allows for multi-stakeholder engagement and for thinking long-term in terms of what kind of legislation you're thinking about. In Latin America, we're mostly seeing very reactive kind of initiatives. And that sort of goes against participation. It goes against thinking long-term of where we want the public conversation on these things to go. So I think there's a lot of hope in looking at the DSA process and seeing how you guys will translate human rights obligations of due process, transparency, access to minimum information into content moderation standards. I guess one lesson learned from the inputs that we already had into our discussions is that maybe what's missing from the European legislation, and it's making it really hard for imported discussions in other regions, is the lack of monitoring and evaluation of what existing legislation that has been adopted during the past 3 or 4 years, how those worked to address the harms that you identified for the identified purpose, sort of. So I'll leave it at that.
Great, Agustina, thank you so much. So I want to take advantage before going to some of the Q&A, which are honestly that we've received some great questions that could each on their own be the subject of an entirely different 1 or 2 hour panel, and we don't have the time to do that. So what I really want to start by taking advantage of the fact that you're all legislators. And I want to ask a question from the legislative process perspective, but it's also in a way a substantive question that goes to the kind of transparency and consultation that I think each of you have identified in a different way. So I wonder if you could reflect for us for a moment on whether you feel that you have enough information and that you and your colleagues have enough information to begin the process of regulation that I think clearly the publics around the world are clamoring for. I mean, is there something missing in terms of the information that you get from the companies? Do you feel that there's enough engagement? I mean, we've had over the past several years these kind of circus environments of senior people coming from the companies before Congress, before parliamentary bodies in Europe or the UK, not as much outside of, frankly, of Europe or the United States. How do you see that engagement? Is there enough engagement from the companies? Do you need more from them? Is there more information that you need in order to begin this process? And whoever might want to start here, and then we'll get into some more substantive questions. Anybody want to jump in with that?
Well, I'll jump in, David, just to point out the obvious, that these are really complicated issues and that a lot of legislators, I can speak for the US Congress, sense there's a problem out there, but they don't fully understand the nature of the problem. It is really, really easy to understand content moderation, right? Everybody understands the concept that something bad is posted on the internet and maybe it should be taken down, or maybe it shouldn't be taken down, right? But taking something down that is bad is something everybody understands. And so much of the debate in the United States has focused on content moderation, which some people condemn as censorship, with some members of Congress demanding that the companies do more of it and other members demanding that the companies do less of it. And what I've been trying to do, and it's admittedly challenging, is to get my colleagues to focus on what's going on under the hood, to try to understand how the engine works, the engine that actually determines what information we all see, and how that bad stuff spreads, and how the spread can be dampened or prevented, even if inevitably people are going to post bad stuff, because in any freedom of speech society, you can't and shouldn't try to prevent people from saying bad things. So, but it's complicated, and therefore, hard to really get a conversation going. I think it's gotten easier in the last few months, certainly the last few weeks in the United States, but that's been the challenge.
Can I add something from my side to the question that
Please,
you
yes.
raised, David? Yeah. One thing that I'd like to also share, because like I said earlier, that we have an authority that looks into the law, interprets a section 37, which is a problem here. But one thing that the companies of these platforms need to also realize, that we have our own languages, we have regional languages. And sometimes the kind of content that is in regional language is not noticed or not I'd say, monitored the way the English language or another international language is looked at. So I feel there has to be more focus and more investment into understanding other languages and monitoring content in other regional languages, particularly that of the global South. So I feel that is one issue that we face. And this is what the platforms available to us need to seriously look into as well.
Great. Thank you. I think that's a really important point about the scope and the reach of these companies and their ability to get at exactly what you're talking about. Alexandra, I saw that you were unmuting.
Yeah, I could just confirm what Tom said. I think that's exactly the problem. And content moderation is rather easy to understand. You delete or you don't. Basically, there's some complications, but that's the easy thing. But how it works under the hood is something very few people in general and very few legislators understand. That is really the problem, and that is really the business model. I mean, I spent months trying to understand how targeted advertising actually works, what RTBs are, and so on, and we're trying to spread that message. But ordinary legislators not focusing on that one issue really don't have the time to go that deeply into technical questions. I wouldn't either look at legislation on chemical substances or something like that. You just trust a colleague who's supposed to know how that works. And I think this is really the issue, that we have these companies that are controlling basically or setting the tone for democracies and for how public discourse works, but that sort of hide behind this technical character, saying, well, we are tech and it's complicated and we can't explain it. It just happened. It's just artificial intelligence and algorithms that will solve everything. And I think until a few years ago, this perfectly worked because people believed that tech would solve their problems. And now we are seeing it's not actually. It's creating new problems, which our constitutional systems are not ready to face. And the companies are not willing to share that knowledge. They don't give access to academia. They don't give access to researchers. So to the people who could really figure that out and elaborate that knowledge in a way that normal people and legislators can understand it. And therefore, I think it is the right, even if we don't feel comfortable and even if we don't have the feeling we are really understanding everything and we have the evidence for everything, we have to start legislating in order to get that kind of evidence, and the more knowledge you gain, the better you can legislate then.
Great, thank you. Agustina.
Yeah, I personally don't think it's that simple to understand content moderation, but maybe it's me. I kind of think the dilemma that you're posing is sort of the chicken and the egg. Sometimes I watch the different debates in different congresses. I saw the hearings in the US and a lot of the interactions of the company reps with Congress people, and I feel we don't even have enough information to ask the right questions. So we might be asking wrong questions or questions that are maybe at some point irrelevant. So it's sort of the chicken and the egg. How do we start a conversation where we don't really know even the very basics of where we want those conversations to go? I also want to raise, there's a very unequal opportunity for different congresses and different governments. Most countries in Latin America don't even have reps from the companies in country. That makes it really hard to get enough information to actually get a conversation going. And the other thing, last, that I want to mention is we might have a conversation with maybe 2 or 3 biggest companies, but there's a lot of other companies that are doing content moderation out there with very different systems for moderating content that are not participating in these conversations as much as I at least would like them to. I would love to hear from companies that don't have a centralized system for moderating content to listen and to learn what their experience has been like and what lessons learned do they have to input in this process.
Great, thanks, Agustina. I'm going to draw from some of the Q&A, some of the questions that people have been posing. Since we don't have a huge amount of time, I'm not going to open it up to ask you to ask the question directly, but there are a few questions that go to business model that I think I want to focus on the way Emma Lanzo put it in her question. So the way she asked the question, and in part, I think this relates to Tom, where you started in describing your legislation. She notes that the real engine of behaviorally targeted ads and targeted content is the underlying data collection and the sale that companies can do without many limits at all. Now, data protection and data privacy has been a long-term debate in Europe in particular, perhaps less so in the United States. And I wonder, and so this is, I'm channeling Emma here, what priority do you put on data protection, whether it's new data protection laws or enforcing existing data protection laws as a possible solution to the problems of business model, of recommendation systems, of content problems and harms, which we could also discuss? Like what priority do you put on that? And I'd welcome anybody starting with that.
Well, I think it's two sides of the same coin. You can try to attack this problem by by limiting data collection, because of course the companies, the process begins with the companies learning everything about us, knowing everything we look at and click on and how much time we spend on every website, and gathering that data, yes, selling it and transferring it, but even holding on to it themselves, they're able then to use that data to determine through their algorithm what content we see. And they match that content, that information to what they think we want to see based on the data that they gather. So absolutely, you can attack this problem from both sides, and I'm open to doing it. I focus particularly on the algorithmic promotion because, as I mentioned, I can just see ways that means that the companies have at their disposal that could very rapidly make a difference. I'll give you one example, which I think is really fascinating. Facebook ran an experiment, I think about a year ago, where they took a small subset of their users and they asked them for a period of time to rate every single post they saw in their newsfeed as either good for the world or bad for the world. And people did this for a while, and the algorithm learned from their votes. And then it created a new newsfeed for them that emphasized content that those very users thought was good for the world. And it was indeed a much nicer newsfeed. There was less disinformation, there was more positive content. And so it was great, except for one problem. Those same users spent less time on the platform, even though they were getting content that they themselves judged to be better for the world, better for them. And so, of course, Facebook discontinued the experiment because what they want is more, right, more engagement. But just that, which was a very clever use actually of big data, right, of monitoring, in this case, voluntary, data that was being submitted by users to create a better experience. But they just couldn't bring themselves to make it system-wide or permanent because they were worried they would lose money. And this is where I think regulatory pressure is necessary.
Great, thanks. Let me, Alexandra, did you want to address the data protection question? In as much as Europe has been so far ahead of others, certainly in a very public regulatory sense on data protection, how do you answer that question? How much of a priority is that, do you think, in the European space moving forward?
It is a very high priority, because if you stop the data collection, you can stop the targeting, and that will stop a lot of bad behavior on the platforms, because as Tom explained, that will take the incentive out for disseminating hateful content or disinformation. The problem is, in Europe, we do have GDPR, which is a great law, but we have a very serious enforcement problem against major companies. It works pretty well against our own public administration, the football club of your kids, and so on. Perfectly, everybody complies with it. When you come to global companies headquartered in Ireland, it becomes a problem. So if you advocate for something like that in the US or in any other country in the world, make sure you have proper enforcement against everybody, Google, Facebook, and Amazon included. This is the problem we have in Europe. The second thing is, when you have basically some kind of duopoly, monopoly, oligopoly of just a few companies who control 90+% of the internet, I think the consent model becomes a problem. Because do try not to give consent to Google. You can't see any YouTube video anymore. We had a few weeks ago, we had Shoshana Zuboff in the European Parliament's committee, and I couldn't attend her lecture, so I wanted to see the recording, and I have to Google my consent in order to see the recording of Shoshana Zuboff's lesson in the internet, given in the European Parliament. This is absurd. And the same thing is true for Facebook. So I think the consent model that we invented in Europe, which was perfect 10 years ago, is not working anymore to that extent. That doesn't mean you shouldn't ask individuals what kind of data they want to share, But I think you need some kind of different model, and you have to be sure that when a user says he or she doesn't want to share data, they don't need to, and they can still use the main services. The last thing is, maybe I think there are aspects of human experience that you shouldn't be allowed, the data on that you shouldn't be allowed to sell. They should just be banned, and that's it. What exactly that is up for definition. But looking at the business model, I think there are things you shouldn't, as the same way you can't sell your organs, you shouldn't be able to sell, the data about your sexual orientation and all that kind of things. And especially all the inference that can be made by basic data, by algorithmic, by artificial intelligence, that's a huge problem too. Because even if you don't share your data and you don't give your consent, whatever is inferred from a group of people that is similar to you in other choices can be applied to you. So you're still a subject to that kind of manipulation, even if you don't share the data. So it's more societal issue. So moving away a little bit from that individual consent approach to a more societal approach, I think that would be correct if you have to make a new data protection law now. Our focus in Europe for the moment is enforcing the one we have.
So we have just a couple of minutes left. So I'm afraid to ask a big overarching. Oh yes, Shazia, please.
Yeah, David, just because back in 2015, this was one of the conversations that we had about data, and Facebook was being discussed, and how there is this vulnerability that one feels, when you're using Facebook, and the kind of information or the data sharing that goes on. So I guess this was a debate, which is why the government at that time was also trying to regulate everything, more with a more dictatorial approach. And we do feel that, I personally do feel that what is discussed about data sharing has to be also more in line with what your society is like, and the kind of values, like my society has certain values. And one issue or one excuse that the previous government used was to protect the girls using Facebook, and the way they're exposed, or the way their data is shared without consent. So I feel, yes, the companies have to respect privacy, have to respect the data, and have to also ensure that the mechanisms in place are more sort of user friendly and to the satisfaction of the user. So that trust has to be there when the companies make a system or initiate these processes.
Shazia, thank you so much for that. I'm afraid that we're really at the end of our time, and given that everybody's busy and probably has other panels or committees or markups to go to, I want to let you go.
Sure.
I think of the questions that we received, I mean, many of them I would have loved to address with you, and maybe to leave with one, which is several of the questions raised the issue of harm. And at the end of the day, we have a significant amount of rather vaguely defined harms, harms that people understand are taking place on the platforms, and are also harms that are generated on the platforms but have offline impact. And I think one of the questions, and I hate to leave with a question, but it's sort of the big question, I think, for legislators and for the public overall, which is, as we look at those harms, who should be deciding what are those harms that the companies should be addressing, and what role should government be playing in determining for the companies how they should make these decisions about the public. They're basically driven by business interests, by business model, and yet, as you've all described, we have a major situation of impact on the public interest. And I think that in thanking you all for joining us, I want to just especially say how valuable it is to have smart and focused and empirically driven people like you who are at the forefront of the debates, whether it's in Pakistan, in Europe, in Latin America, or in the United States. So I'm sorry that we didn't have enough time. Next time we're going to take up 2 hours of your time. But Shazia, Tom, Alexandra, Agustina, thank you so much for joining us. To Jason and David and everybody at GNI who helped make this happen, thank you for organizing it. It was a really interesting and important discussion. Thanks, everybody.
Thank you.
Thank you.